Dear intellectual property friends from all over the world, good afternoon. As you perhaps know, the color of intellectual property law is green, and therefore I got my green sweater today. On behalf of the board of the Institute for Intellectual Property and Market Law at the Stockholm University, I would like to welcome you to this webinar where we will analyze, evaluate, and discuss the potential impact of some of the most relevant provisions of the so-called Digital Service Act, or DSA. Following an overview of the current state of negotiations, some of the key stakeholders will offer their views on issues which are currently being debated in the context of the negotiations. And by that, I would like to give the word to our director, Professor Eleonora Rosati. Please.
Thank you very much, Per Jonas. I would like to start, of course, by welcoming all participants to today's IFIM webinar. We are very happy to have participants indeed from so many different jurisdictions, and we are keen to discuss a horizontal piece of legislation, the Digital Service Act, and see what the potential impact thereof will be on intellectual property. So we are not unfortunately able to have Flavio Arzarello with us due to a clash in the schedule, but we are very happy to have all other speakers with us today, and the structure will be as follows. We shall begin with an overview of the current state of negotiations. As indeed has been noted, the DSA is currently going through trilogue negotiations between the European Commission, Parliament and the Council. After that, we will be hearing from some of the key stakeholders in the debate regarding their views about the shaping of the DSA and the relevance to intellectual property. And then we will be discussing the interplay between the DSA and Article 17 of the DSM directive, because if there is one thing that is certain, is that the discussion around Article 17 is far from over, and indeed also the eventual shaping of the DSA will have an impact on the application of this provision. So I would like to start by inviting Clothilde Goujard, who's a tech reporter at Politico, to give us an overview of the current state of negotiations. You, Clothilde, cover on a daily basis updates on the DSA, so there is a lot to report and discuss, and we are very keen to hear from you. So the floor is yours. Thanks.
Thanks, Eleonora. Yes, so I cover the DSA as well as a number of tech files in Brussels for Politico and for our audiences. Thank you for the invitation, first of all. It's really nice to be speaking to such a big crowd about a specific topic on the DSA. The Commission proposed this text in December 2020 to replace the e-commerce directive that had gotten a bit out of date in 2020. The idea, as most of you probably know, was to set some rules to better tackle illegal content online across the internet. So it's a very horizontal, very broad, and very complex and lengthy piece of legislation. And despite all of that, it has been going very fast. I've been in Brussels at Politico for only a year, but from what I've heard, it's such a record speed. And that's because different actors from different EU institutions have made it their priorities to finalize two of the major tech bills, the Digital Markets Act and the Digital Services Act. So where we are right now is that the Council, representing the 27 different governments, reached their general approach, so their version of the text, in November 2021. And the Parliament was a little bit slower, but technically it was super fast as well. And they got their position in plenary in January. So following that, what they did is they entered trilogues, which is when they negotiate on their common version of the text, and the commission acts as the honest broker trying to bridge the different positions. This has gone very quickly. The timeline is very ambitious. That's also because right now at the head of the council you have the French. So Paris is very keen on finalizing these tech bills, and you have the French elections coming up, where the current president Emmanuel Macron is trying to get reelected. So it's both an ambition for him to finish before the election, but it's also a big hurdle. So far they've been going very fast. You've had 3 different trilogues. So trilogues are the high political discussions with the top officials from all the 3 institutions. And then you have almost near daily technical meetings. Maybe not daily, but there's a lot of them, and a lot of documents and compromises are being exchanged. So it can be hard to follow every single part of the text, but I'll do my best to try to give you an overview of where we are on some specific points that I think are more of interest for your community, for everyone who's interested in intellectual property. Obviously, there have been lots of discussions around dark patterns, targeted advertising, and things like that, but I'll try to be a bit more focused since the text is so lengthy. So some of the things that we've seen is so far we haven't had some very clear agreements on parts of the text. It's mostly a lot of discussion, very thorough discussions at the political level, and then they do a lot of the work on the technical level. But so far it's still a bit fuzzy what has been kind of accomplished and agreed on. There's still a lot of work to do, and yet a lot of the officials seem to be very confident that they will manage to close the negotiations by April. So we have the next trilogue, so the next political discussion is tomorrow. And then there could be, or there will likely be, another political discussion by the end of April. And they will use the month of April to try to finish everything. So that's pretty ambitious. I'll start with search engines. So in the DSA, you have different categories for the sort of liability and due diligence obligations, depending on the types of actors, because as the Commission loves to say, it's a horizontal text, so it will apply to so many different actors. What happened basically is the Council, so the 27 EU governments, proposed in their version of the DSA sort of a new safe harbor, where they would classify search engines as caching. They also want to explicitly add very large search engine, the like of, you would think, Google, within a category that's called the very large online platforms. And these very big tech companies basically would face more obligations for transparency, but for things like risk assessment and mitigation, for the dissemination of illegal content through their services, for example. So on the Parliament side, they kept a text that was closer to the one that was initially proposed by the Commission. And so as of now, we're in this time when they're trying to bridge these positions. So according to the latest document we saw from the French presidency, this specific rule, which is the Article 4, they said it had not been discussed yet in enough detail with the Parliament to propose to the other countries some new wording. So as of now, they have stuck with their initial wording, but you have the Commission that came forward yesterday. So this is all very new and very fast and developing, might change as of tomorrow. The Commission proposed a new idea to try to bridge positions where they would propose a different article. So the idea is like 4A, with a specific liability regime and due diligence obligations specifically for search engines, because they say they don't correspond perfectly to caching or hosting services. And so they would align their wording to what we have seen in the US with the Digital Millennium Copyright Act, that I'm sure lots of you are familiar, and even more familiar than I am with this. And they just, so in their notes, in the documents we saw, basically they were justifying that this would be the way for them to go within the DSA. to try to solve this legal uncertainty. This is what they proposed yesterday. This is not on the political discussions, at least it's not on the agenda we've seen for the discussions tomorrow, so remains to be seen what they will do. It seems like the parliament is quite open to the discussion, so we will see what happens with that. The next point that I wanted to talk about, sorry, I'm having a light issue. It's good for the environment, but not so great for a webinar. The other one is notice and action. And the DSA users or organizations can notify a provider about illegal content, so the provider can take it down. And once they become aware about this illegal content, the provider becomes liable. So this is a particularly important article. And so for rights holders, there have been worries about the Parliament's position because they changed a lot of the Commission's initial proposal. And for example, they mentioned that the information in the notice, so the potentially illegal content, had to remain accessible while the assessment of legality was still pending. They also added wording that if the provider had no technical or operational ability to act against the illegal content, it could kind of tell another provider that's supposed to be in charge of this. So where are we now? It's moving forward. We don't have any specific agreement on that yet. There's been it's getting closer to sort of the elements that would be needed in the notice. So that's where we are. The Commission has proposed a compromise with more wording and tried basically deleted some of the Parliament's take on it. So seems like the Commission is probably leaning more towards the Council's version. We will see whether the Parliament agrees with that. The Parliament came from a sort of freedom of expression perspective where it was just fearful of over removal. But again, because it's a horizontal text, it applies to everyone. It's something that is not, that will be debated in the, sorry, I'm looking at my notes. No, it's not on the agenda for tomorrow's trilogue. So it will be one of the thorniest issues to be discussed in the coming week where there haven't been most progress. In terms of another thing that's important is the trusted flaggers. So the specific organizations that would be fast track if they submitted a notice. Parliament and Commission do not want trusted flaggers to represent potential IP rights. So they would want trusted flaggers to represent collective interests, something that the Council removed. It was in the technical discussions mentioned yesterday, but still nothing that was discussed. The Parliament is really sticking with its position there. In terms of marketplaces and traceability of traders, it's been one of the key issues for the lead lawmaker in Parliament on this, MEP Christel Schaldemose, as well as for some countries within the Council, like Italy, Spain, and Denmark. This is one of the rules where lawmakers have been moving forward with that the most, adding more obligations. They have, however, not extended sort of the requirements for traders to all of the intermediary services, and they've stuck so far with online platforms. The Parliament is still pushing for online marketplaces and online platforms to do random checks to ensure that there's no counterfeit content. However, that's not something that, so far from what we've heard, that's not something that the Council or the Commission are particularly favorable to. And it's unclear that the rapporteur will be able to really, she is really interested in this idea. It's unclear that other parties will really support her on that in the future within the Parliament. But this is one of the parts that is where we're slowly getting there. I'm looking at the time and I feel like I haven't typed myself properly and I'm running out of time. So the other parts where we're getting probably closer to some form of agreement is the part about the enforcement. It seems like the Commission is looking more likely that the Commission will be in charge of overseeing the very large tech platforms and their bigger obligations. They have also proposed to create a specific fee for these big tech platforms so that they can have additional human resources to actually oversee that these platforms are complying with the DSA. So most of in a way, everything is still up and unclear where it will still go. There has been some progress, but like I've said, there haven't been very clear agreements on anything actually so far, even though they want to finalize it by April. Overall, it seems like the council has shown some willingness to move closer to the parliament position on everything that has to do with marketplaces and risk assessments and risk mitigation. There is a fourth trilogue tomorrow, and there might be some more progress on everything that has to do with risk assessment and mitigation, as well as enforcement, as well as an exemption for small and medium-sized companies. It's probably really important that they finalize by the end of April, because the French have their last round of elections on April 24th. And the current digital minister in France has said he would not be staying in government and would move to the private sector. So that would mean there would be a little bit of some unknowns as to what happens following the French elections. Also, if they don't close this before the end of the French presidency, it will move on to the Czech presidency, and the Czech haven't had the same interest in the file that the French have had. In terms of timeline, then, it could potentially be voted and finalized as a whole before the end of the year, because even if we find an agreement in trilogue, they still have to go back to council and then to parliament. So there still the process is even longer. So then it could potentially be done by the end of the year if the timeline keeps that way. Then in terms of implementation, the council wants the DSA to apply 18 months after it goes into force, while the parliament wants 6 and the commission wants 3. So there will probably be some bridging there. It's unclear. It seems like the idea would be a year. I think that would probably, it seems like from what I've heard, that would be what they would like to make it happen. Sorry for the presentation that went a little bit over time. I hope it was interesting, and thank you for the invitation again, Eleanor.
Absolutely no, Clothilde. Thank you for giving us such an up-to-date and comprehensive overview of this very complex piece of legislation. We got a question from one of the attendees who would like to ask you to elaborate a bit more what the latest is regarding trusted flaggers.
The latest is that there hasn't been much. There's still a lot of discussion on that, but it hasn't. There is no agreement on this, and it keeps being pushed back. So sorry, that's a bit of a disappointing answer.
No, I think that this shows how difficult it is to find consensus on these provisions, and how ambitious, as you have indeed noted, is the timeline that has been presented by the French presidency. So we shall see how that goes. So I think that now we can hear from our invited stakeholders what their take is on the shaping of the DSA, and then of course anyone, and feel free to jump in at any point. And I repeat, if any of the participants has any comments or questions, please do use the Q&A function. So as part of our panel today, we are very happy to have Linn Berggren, who is a regulatory and public affairs manager at a Nordic Entertainment Group based in Stockholm. Then we have Jaymeen Patel, who is the head of the Brussels office of LVMH, and then with us, Ludvig Werner, who is the managing director of IFPI Sweden, also based in Stockholm, that is the International Federation of the Phonographic Industry. So you represent mostly the right holder side of the debate. Again, Flavio Arzarello could not be with us today, but of course you represent different industries, and also you have a focus on different IP rights. So let's start with you, Ludvig. Of course, one of the presented goals of the DSA will be to create greater accountability, transparency of digital services. So after so many months discussing these provisions, what is your take at this stage? How do you see the DSA taking its final form?
Well, I mean, thank you, Eleonora, and it's fun to be here. I think it's very interesting, and thank you, Clothilde, for the update, because there was some news in what you just said that I hadn't heard about, but we'll probably come back to that later in the discussion today. I think, I mean, we received the proposal from the Commission back in 2020 with great interest, and I think, I mean, the starting point is very good and fairly clear, as you said at the opening speech, Eleonora, that this is to ensure greater accountability and transparency of digital services, etc. So, well, where are we right now? And I must say, I guess myself and I guess my industry is fairly disappointed, because right now, unfortunately, we are in a position where we might even have areas where we take a step backwards to where we were before the DSA. And as you say, I mean, it's a very complex material. It's a lot of legislation in many areas with the horizontal sort of perspective. But I think still it's so crucial that the DSA doesn't make anything worse than from the outset, specifically from my point of view for the copyright industry, of course. And it's also a bit absurd that that's actually what I have to say opening up, because I would love to say that we're so happy about these, you know, the progress that's been made in so many areas in the DSA discussion. But if I just take a couple, I mean, we're not going to overtake my time here, but some of the areas that are, of course, more problematic from our side is the discussion on search engines. So therefore, that would be interesting to hear what the discussion tomorrow might lead to, that you mentioned, Clothilde, on if there might be an attempt to find a third route or some kind of a new solution. Because right now we are actually discussing, and we even use that word in describing the process, a new safe harbor. So instead of actually assessing what is happening and what is a search engine actually doing, we're discussing this sort of the caching area to actually create a definition before we even try what's happening in the search engine, online search engines, to define a safe harbor. And I think we should learn from the entire DSM process over the last 6 or 7 years that safe harbors are problematic. So we shouldn't create new ones. We should at least, maybe we should still have the old ones, because we know what that's been said about them in the e-commerce directive, and we know the limits to some extent. But that's one of the sort of most problematic areas I see at this point. There's also the discussion on subsidiarity. Basically, this could also be sort of a step back, because this is about who should you address with your complaint. And the discussion on subsidiarity basically means that you should first seek the original website that published this illegal content. And you need to do that before going and trying to take the help of an intermediary in solving this issue. And that really means that going back to the initial website means that you will probably spend a lot of time and money to try to trace websites, which will be very hard or impossible to identify, because there's no identification information on many services online. And they might even be placed in a country where you don't really have a practical possibility to press charges. So, and that also actually lead to the entire know your business customer discussion. This is such a great opportunity and possibility to actually make sure that everybody that's actually running a service online needs some basic information published, so that we can reach them, or someone can reach them at least, instead of actually now sort of conforming or eliminating the total area of know your business customers areas to only be relevant for the marketplaces. Actually, in our world, the recorded industry, there will be an extremely limited effect or possibility to use if it's only marketplaces. I think it would be vinyl counterfeit or CD counterfeit products. That's the entire use we can have for this in an almost completely digital world. That's also a bit sad, to be honest. And then I'm Swedish, Pirate Bay. I don't know how much money that's been spent on trying to chase Pirate Bay from country to country. And I think, and I would hope for sort of a more ambitious DSA on how to work on a cross-border how to be able to use legislation or processes across border when you have sites that actually work on a global scale. So I think I stopped there, but that are sort of the concerns. But of course, still, I mean, the entire sort of starting point for the DSA is to make things better. And when I hear these discussions going on and on now in the trilogue, I hope that more needles are changed from the current position. Thank you, Eleonora.
Thank you, Ludvig. Before we go into the specifics of some of the provisions that you have indeed identified, I would like to ask the rest of our speakers what your general take on the DSA is, whether you share Ludvig's feelings or you have a different view. So I don't know if anyone would like to say something.
I can just start with saying that I think I just took note that I could co-sign most of Ludvig's reactions here. So that's just a short reaction.
Jaymeen?
Yes. Yeah, I would agree with many of the points that Ludvig made. I mean, obviously, we're not exactly in the same position because our business is in products, and so trademark is much more relevant to us than copyright. But indeed, a lot of the tools that are used by that could be used by the copyright industry would also be used by us. And most notably, I think this idea of KYBC is worth exploring, perhaps in a little more detail. So, if you don't mind, we can maybe move on to that. And for us, KYBC was one of the most important innovations in the DSA because it really allowed for a differentiated approach to be taken between individual interactions and transactions. Because let's not forget, the DSA is meant to be a revision of the e-commerce directive. So the commerce part, should be an important part of it. And KYBC allows obligations to be placed on business, which better aligns them with the current prevailing cornerstones of European consumer policy, which is to say, if, as is the case in the physical world, if you're a business and selling to consumers, you need to be identifiable and contactable in case something goes wrong. And so this principle of KYBC should, in theory, allow to create reliable value chains across the internet, where if as intermediaries, you're not liable for the illegal content or conduct of someone who's using your services, you should at the very least be able to point to the person at the end of that chain. And so from our point of view, it's really, really important that it applies to all relevant actors online. Already today, I think we see that beyond search engines, there are other online intermediaries beyond online marketplaces as well that play a very important role in the consumer journey from discovery, exposure, and finally consumption of and purchase of products. It's not just simply the place where you click on the buy button, which is currently the definition that's being used in the trilogues are on the DSA. And just to give you an idea, I mean, already a few years ago, we found a study that showed that 25% of all online counterfeiting was to be found on online marketplaces, and whereas 40% was already present via social media, and that's a trend which I think you can agree is only got more extreme in the world of today and will be tomorrow. And that's because counterfeiters are very agile actors, and if they weren't dealing in illegal products, they make very good businessmen. And so they go where the consumers are. And I think moreover, what they do is they exploit the trust that consumers have in these platforms. They feel that they can have a sense of confidence in what's being portrayed to them on social media, and they think if they've seen an advert that someone must have checked it. But unfortunately, as the Brexit referendum showed, that wasn't the case at all. We've also seen that there's a recent FTC study that showed that the highest number of reported scams to them from American consumers was to do with adverts for products on social media. And so from my point of view, if we want a DSA that's not already obsolete on the day it's adopted, we need KYBC obligations to apply to a wider set of online platforms, and at the very least, advertising networks who are directly benefiting from turning a blind eye to this kind of false advertising that we're seeing across their networks.
Thank you very much. Before we continue with this important discussion, I think that Jaymeen made an important point, that is the risk of obsolescence of these provisions. Perhaps, Martin, do you want to comment on this risk? Do you see that there might be a problem there, generally speaking, by looking at the DSA as a whole?
Sorry,
I think that Jaymeen made an important point regarding the risk that some of the provisions of the DSA might be already obsolete when they are adopted. So I would like to seek your input, whether there might be this risk in the DSA as a whole, or at least some aspects. For instance, something that comes to my mind is the URL indication requirement in the notice and action mechanism. So perhaps, from your academic perspective, Martin, whether you think that this risk is real.
Yeah, well, I would agree to that. I also see this risk. Actually, I'm a bit surprised that after this very rudimentary legislation we had in the e-commerce directive, we are now suddenly getting, let's say, the other extreme with very, very detailed rules and different categories of liability and notice and takedown and action regimes and so on. So on the one hand, I think it is, of course, a very good signal that the lawmaker is so actively looking at this. At the other hand, when I look at the text, for instance, including the amendments of the parliament, this is almost a monster. I mean, a text of this with that much detail in a high-tech area that is moving so fast is, of course, at risk of being relatively outdated with regard to several aspects. I think there is an underlying problem here that following the civil law tradition, there is, of course, this tendency of trying to fix and deal with the issues directly in the legislation, and finding the right balance between detailed rules on the one hand and sufficient flexibility also for what comes in the future is something that has always been a bit difficult in the European Union, I think, and this is another example of this. But having said that, I really appreciate the effort that is currently made. And I mean, you can also ask the question, well, if some of the provisions get outdated, is that much of a problem? I mean, there will still be enough substance left and enough opportunities to derive more general approaches from the text that is left. So yeah, I'm not completely critical about the approach in general.
Perfect, thank you. I see that the questions are coming up in the Q&A, but let's discuss, a bit more in detail some of the provisions that also, Clothilde mentioned in her opening speech. And in particular, we've seen the KYBC regulation, and of course, there is now this question of safe harbors and the qualification of search engines. So that is a really topical point, and I think that from Clothilde's remarks, it is apparent how controversial that entire chapter is going to be. So Linn, what is your take regarding safe harbors and in particular the treatment of search engines?
Thank you. And as several has already been stating, like Ludvig initially and Clothilde has already mentioned, now we see some developments that might be potentially positive, but let's still discuss it from the point of view of the text that have been seen so far. And I guess that the council sees an opportunity here to clarify what they see as necessary to provide more legal certainty. However, I believe that this is not really clarifying, but more confusing, as caching services are normally another type of function, or they have another place in the infrastructure chain, let's see, and that's why they are treated differently than hosting services. But this is a bit unfortunate, and they are treated differently because they are simply unable to act on notice and action in this way. So if you want to clarify something, maybe one should instead look at these American rules that Clothilde was also referring to earlier, where I understand that they have something called the information location tool, which is more accurate in our view, just to pin down the type of service that a search engine actually is. So this is for us. It's just unfortunate. We see that this became a discussion as a caching safe harbor, as it looks currently in Article 4, so if this new proposal is successful, that would be a better solution, I think. But let's not preclude on that yet.
Do the other panelists wish to comment on the question of safe harbors and treatment of search engines? Anyone would like to add anything? From my part, I would like just to point out that I remember that back in the 2000s, there was the first report of the European Commission on the transposition and application of the Commerce Directive. And there it was expressly noted that search engines were outside the Commerce Directive. They were treated in accordance with some national law, but they were not part of the harmonized EU framework. So I guess that here we are not speaking of clarifying the law as it has already been in place for over 20 years, but it is about doing something new and additional to the harmonization level that we had so far.
Eleonora, very briefly, it's also actually would make things worse because I mean there's been development of a sort of a best practice on actually how to handle these issues today. So by actually defining this safe harbor would actually make some of the solution that's been grown on us for the last 10 years would actually be reversed to be worse, and would sort of entail the search engines to do less than they did before. So in many ways, it would be a very bad development.
Thank you. I don't know if Jaymeen, Clothilde, or Martin wish to add anything on this point. And then if not, we can continue by looking indeed at the harmonization of the notice and action mechanism. And there are many things of interest to discuss in Article 14. At some point, there was also the idea flagged by the European Parliament of introducing a stay-up requirement, but Clothilde, correct me if I'm wrong, that seems now to have been abandoned. So, Jaymeen, from your point of view, how should this framework be shaped in the end?
And thank you, Eleanor. And yes, I think that's also how I understand it. As I'm speaking, I realized that I look like the Wizard of Oz because my camera is so much closer to my head than yours, so I apologize for that. No, I think, in the absence of proactive measures, which we were expecting to have in the DSA, because as you said, the way in which it was described before publication, there was a lot of very strong talk about making the platforms more accountable, holding them to become more responsible actors, fighting against illegal content, illegal goods, counterfeit was specifically mentioned. But in the end, they've sort of decided to maintain the retroactive approach that was in the e-commerce directive. Having said that, they finally managed to get some definition around what notice and action should look like, which wasn't in the e-commerce directive, as you know. And so that's a step forward. However, I think a little bit like with what Ludvig said in terms of what's currently the best practice in terms of voluntary actions between rights holders and platforms, this mechanism, if it goes through as it currently drafted, would indeed be a step back from our side as well. Today, there are a few platforms that have their own trusted flagger mechanisms in place that handle, I heard just yesterday again, several tens of millions of brands in their systems. But according to the DSA text, where we as individual brands will no longer be eligible to be trusted flaggers. Now, I know that is trying to take into account certain kinds of work on illegal content, like child sexual abuse, and to a certain extent also from the copyright world, who have a more collective approach in certain parts, including potentially on reporting, depending on the type of content. But in terms of trademarks, in terms of counterfeit, brands are the only entity that can tell you for definite if a product is fake or not. There is no real other way for a collective organization to be able to identify the products that you're making and are being copied by others. And so if we have to be part of a collective interest organization, all that does for brands is add a layer of time, cost, and bureaucracy, which of course would hit smaller SME brands particularly hard. A collective entity would have no role apart from to receive notices and pass them on. There is no expertise within those collective organizations which would add any more legitimacy to the notice than the brand would already provide, and we already provide today. And the risk we see is that actually increases the risk of so-called bad faith reports. So the kinds that platforms often complain about when they refuse to be more proactive in fighting counterfeit. They say that there are brands that use notice and action mechanisms on counterfeit to remove their competitors' products. Well, we still haven't seen any numbers on that as to whether that's a phenomenon and how big it is. But if there is a collective interest entity standing between brands and platforms, there is actually less risk for a bad faith actor to send those reports through the collective entity, and actually then put at risk the other member brands of that collective organization through no fault of their own. So I think that actually adds not only cost, time, and burden, but also increases the risk of this notice and action mechanism being abused in the way in which platforms say that it's being today. I know that some people have expressed concerns about if brands are allowed in to be certified as trusted flaggers, and I think that's also another point that's important, that this is not just a status that you can pick up yourself and run with. You have to be certified by the Digital Services Coordinator as a trusted flagger. There isn't just simply a tick box mechanism. So there is a very clear incentive to work positively within that system for fear of losing this trusted flagger status, which, as I said earlier, is a very important part of the notice and action system for us. But there is a concern that there are so many brands that would apply that it would overwhelm the system, which I think is a bit of a strange counter argument. It's like saying, well, there's a lot of crime in this area, so what we'll do is we'll restrict the number of people who can call the emergency services because otherwise they'll be overwhelmed, and that's a problem. I don't think that's looking at it from the right side of the telescope. If there is a big counterfeit problem, then brands should be able to flag that, and if there isn't, then that's good because platforms have done their job. I don't think there's this idea that they will overwhelm the system, and I think there are definitely ways that we can work with digital services coordinators, potentially via collective organizations in that respect, to gain certified status for brands in a more cost-efficient and time-efficient way.
Very clear. Do the other panelists wish to comment on the points that Jaymeen was making? Please, Martin.
Yeah, I'm just curious. I mean, when this discussion played a role in the past, there was also quite a couple of statements saying, well, it's such a pity that at the European level, we don't have clearer guidelines for how to actually shape these procedures in practice, because there is a lack of harmonization, and so it's difficult to develop processes that can be applied across all EU member states, because now with this being left to the courts, one member state say, okay, we want the notices in format A, and another member state says we want the notices in format B, and so on and so forth. So I'm still a bit surprised to hear that, I mean, the general approach saying we should find common ground in that area, and many of the rules that we now see in Articles 14 and 15, at least in the wording that has been proposed by the Commission, do not come that much as a surprise. I mean, they are distilled, of course, from case law developments in EU member states and so on. So do we really have to be that critical about 14 and 15 being now proposed and trying to establish a common ground? You could also say, well, this helps platforms to develop a system that can be applied across all EU member states.
I would agree with that. I think one of the many barriers we have as brands in reporting counterfeit is that each platform at the moment decides for itself how and how quickly and in what format to process notices. So there are some that require you to actually show the trademark, to show that you are the trademark owner before they will process a notice. There are some that insist on every single product that's been identified to be notified individually, that you can't just notify a seller. There's an incredible amount of variation in the notice and action mechanism, which is why I said bringing some commonalities to it would be a good help. I think that can hopefully be worked on in delegated acts after the DSA has been adopted, certainly in terms of reporting procedure, but also potentially a reporting portal, either at national or even at European level, to allow that mechanism to work better for businesses of all sizes. One other point on the notice and action mechanism that we would have liked to see is the idea that once illegal content has been identified, that the platform makes sure that it doesn't come back again. And certainly in our case, what we're talking about here is counterfeit that's being sold by professional entities, i.e. that should, under the KYBC mechanism, already be identified in a verifiable way, so that once they have been caught selling fake products, not only are they removed, but they can't easily come back in the way in which they do today, which is to simply change the username just slightly while still maintaining the same contact details, the same phone address, email address, WhatsApp, etc. So without that notice and action mechanism, we will unfortunately continue with a slightly more efficient notice and action mechanism, but one that's just as ineffective, i.e. that we'll identify illegal goods, they'll be removed, and they'll come back on within a matter of minutes or hours. So unfortunately, I don't think that's part of the trilogue discussions, but we felt that a stay down that's specifically limited to business users of intermediary services, i.e. those that have been identified under KYBC, would have been a really effective end element of the notice and action mechanism.
So indeed, there was a question asking about stay down obligations, and that will be also an interesting point of contact with Article 17 of the DSM directive, which Martin will discuss, because that seems to impose indeed a stay down obligation. So there will be points of contact and possibly also sometimes conflict between the rules of the DSA and Article 17. Please, Martin.
Yeah, just a quick question there. I mean, looking at it from the trademark and industrial designs counterfeit perspective and so on, I was always wondering, so in the ideal world, what would this stay down obligation look like? Because you, of course, never know whether something is, let's say, the counterfeit coming from countries outside the European Union or a legitimate parallel import that is offered within the internal market. So, I mean, stay down with regard to the same seller is something I can follow as an argument. But if I understood you correctly by saying, well, the seller just changing the name and then basically offering the same counterfeit again, well, how would you distinguish then the legitimate offers from the illegitimate offers?
Well, and we're talking, let's be clear here, what we were talking about is a notice that we have sent where we're sure that it's a counterfeit product. We're very careful to not incriminate legitimate sellers. But there are areas, for example, where there are certain marketplaces where we do not advertise. There are certain social media where we do not advertise. We know that our products shouldn't be present in those on those platforms. Also through selective distribution agreements that we have, which mean that parallel imports can be limited as much as is allowed by the vertical block exemption regulation. We're not talking about legitimate sellers. I think that's really where we're very clear that this is an illegal piece of content which the platform has agreed with us on because it's removed it. We're talking about content that's been removed. There hasn't been an appeal by the legitimate seller because we totally agree that there needs to be an appeals mechanism to avoid abuse. But once again, if you're a certified trusted flagger, there's a strong interest for you in not abusing that status. So these elements all work together, from my point of view, to make this strong notice and action mechanism. Now, the way I was talking about it was, if once that content has been removed, i.e. the platform agrees and there's been no appeal, what we see today is that that seller then simply comes back onto the platform with a slightly different username, but with the same brand logos that they've created for themselves, the same WhatsApp contact numbers, because they have brands that they want to sort of promote as well. But with a strong KYBC that grows across online platforms, because otherwise all they'll do is move from online marketplaces to social media or wherever it may be. If KYBC applies, then they can't do that as simply as they can do today. Does that make sense?
Thank you. So still on the topic of Article 14, we were discussing before the potential of having a stay-up requirement, and as we were saying, this seems now to have been put aside as an idea. But Linn, can you please tell us what your take will be on having such a requirement, and what it would actually mean if it was introduced or reintroduced in the context also of the negotiations?
Yes, I mean, from our perspective, I think there are two aspects of this that I would just like to briefly mention. And you already went into this URL requirement to mention specific URLs in the notices, where we already concluded that this might be outdated quite quickly, and it might also be in the contrary into case law from the European Court of Justice. But on the other topic, what I would just like to raise in this context is the discussion on the concept of the actual knowledge, which I believe should not be altered. Whereas the discussion here on when the duty to act should arise, where I understand that now the legislators are considering setting that after having obtained knowledge and awareness of the illegality at hand, whereas we believe that this might have to be exactly when you obtain such knowledge. So that this is otherwise otherwise it would just abolish or just abandon the idea of having they would just the incentives to act expeditiously would just be annulled, is from our view. Talking about notice and action. So that was just adding to the Article 14 debate. Thank you.
Thank you, because indeed, I mean, if we look at Article 17 as the most recent, example, it seems that the duty to act arises upon receiving the notice, no? So that would be the moment in which this obligation does arise. But indeed, in the discussion that you outline, it might seem that this duty to act expeditiously would arise not when the notice is received, but once the notice has been processed. So that might lead to delays, and I guess that for content like also audiovisual content that is time sensitive, as it might be, a live event, etc., might be, quite a problem from your point of view.
Indeed.
Okay, so there is an interesting question that was raised in the Q&A, and it is the risk that imposing all these obligations on different types of internet actors might have chilling effects. So it is a discussion that resembles a bit what we've seen in relation to Article 17. So I wonder whether any of the panelists care to comment on the fact that having a more stringent set of obligations on internet actors might lead to a restriction of freedom of expression on the internet, but I would say potentially also freedom to conduct a business, which is also a fundamental right guaranteed by the EU Charter of Fundamental Rights.
Yeah, maybe I can kick off, but happy to let Ludvig.
Please go ahead.
I mean, I think the way we look at it is we want to create a trusted environment where people have confidence that what they buy is what they want to buy. And currently that's not the case. And just as we endeavor to create safe spaces for people to go shopping in the real world, where they're not afraid to come across fake goods, because there's a chain of confidence that runs through via obligations on businesses to identify themselves. We think that's actually a good way of creating confidence amongst users online, and actually creating sustainable growth for e-commerce going into the future. At the moment, what we see is that 40% of counterfeit is bought by people who aren't aware they're buying counterfeit. They inevitably have a bad experience. And at the moment, what happens is they either blame the brand, or they think I'm going to be wary of shopping online in the future. That's not a sustainable way of growing this space. And we think that having these simple rules, which already apply offline, can help deliver that sustainable growth of online commerce.
Thank you. We have Martin and then Ludvig.
Yeah, I think this is really an important point. I mean, first of all, what we also see in this proposed new legislation is that the European legislator is aware that much of these new rules are, of course, aligned with the experience we have with the big platforms. So they make distinctions there, different regimes for very large and so on and so forth. Because I think small and medium-sized platform providers are, of course, in a difficult position here, or can easily be brought in a difficult position if you impose obligations on them that are just too heavy, considering let's say the general traffic and volume of interactions that they have on their platforms. Another issue, and this is not so much a comment, but just to point out, I mean, there is this famous Article 12 of the DSA package, which is really remarkable, because on the one hand, it recognizes this risk of inroads into freedom of expression and other fundamental rights, but at the same time, it passes this on, or we could say it's a type of outsourcing to the platforms themselves. So the platforms become basically the referees for ensuring these fundamental rights, which from a legal perspective, and we think of fundamental rights as rights against the state and state power, is a very, very remarkable step, and also could change the color of our thinking about fundamental rights quite fundamentally, because I guess platforms would try to deal with this in the most cost-efficient manner. I'm not saying this as a critique or something. This is just, I mean, we must realize these are commercial businesses, so that's the type of behavior that we would expect. So I think the provisions that we now see can easily have quite a corrosive effect on fundamental guarantees like freedom of expression, freedom of information, and so on and so forth.
Thank you. Ludvig, please.
I would probably say, though, that I think that for the business and the commercial side, strict or clear rules are always the most important in order to conduct your business. I used to work both in the music industry and also in startups, usually connected to music. And I think it was imperative and sometimes extremely difficult, if we go back 10 or 15 years in time, to actually understand what rules applied, especially when we had the different set of rules in the US market and Europe. So my hope, because I think the question is extremely relevant, because of course the respect for fundamental rights is sort of the base point where we start. But I still think that clear rules for the businesses and what kind of environment they act, and the knowledge that their competitors will have the same rules, I think it will not create less business. I actually think they will create more business and clearer rules for investors, etc.
Jaymeen?
Hi, maybe just to gently push back on what Martin just said. I've always found it a strange defense to say, I can't comply with the law because I have too many customers. It seems to me to be a very strange defense. If I build a building, I can't say, well, I ran out of money to build enough fire escapes or have enough fire extinguishers. That's not how we do business in the real. You have responsibilities as a business to follow the rules. We don't say, hey, medical startups, it's okay to ignore some of the rules around safety when you're developing new medicines because we need innovation in this space. There are certain basic tenets in European law around consumer protection, around level playing field, which you need to respect. And just because you're doing things online rather than offline, that doesn't, I don't think, give you an excuse to say, actually, this is too much work for us to comply with the law. And I find that very strange as a defense, to be quite honest. On the free speech side, again, it's a bit, sometimes I find the platforms say, well, they're just neutral places where people can come together. And effectively, they are the public space, the new public space for European citizens to communicate with each other, which goes back to the point about who's supposed to be protecting free speech and who you're protecting your right of free speech from. And at other times, they're commercial actors. For me, it's very difficult to be both. You either run a nightclub or you're managing as a council, the town square. You've got to pick one or the other.
Thank you. I don't know if Martin, you wanted to react, please.
Yeah, just a couple of words. I mean, first of all, I find this last comment is really an important one. We see, of course, in the whole debate that all the players have found their figureheads. So, I mean, of course, the platforms have found the vulnerable users who want to express themselves and so on as figureheads for saying, well, there are freedom of expression concerns and so on and so forth. But on the other hand, there's lots of research also showing that these concerns are growing and that there are new forms of interaction also with brands, for instance. There are initiatives about sustainable reuse of secondhand clothing and so on, the whole upcycling discussion or use in the buzzword non-fungible tokens and so on and so forth. So there are more and more things coming up where we see the intersections between, on the one hand, protection of intellectual property, which is legitimate, which is, of course, in the Charter of Fundamental Rights, we know this very well. And on the other hand, freedom of expression. And the Court of Justice is very clear on saying there must be a fair balance between these different values, and they have equal status because they are equal as fundamental rights and freedoms recognized in the Charter. So we have to think about these issues. And as to the former point about small and medium-sized enterprises also being obliged to do their job, yes, I agree. And I mean, this is also in the DSA. Of course, everybody has to work towards an environment that is as much in compliance with the law as possible, and ideally fully in compliance. But still, I mean, when you look at the measures which a large platform can take in comparison with the measures that you can expect from a smaller platform, which perhaps does not have to implement all the specific things like reporting duties and so on. There are nuances that are possible. And I think this proposal that we see also tries to make these differences. So I just pointed this out as something that has been addressed in this legislation, I think, and rightly so. If you want to have a chance as a European small, medium-sized enterprise startup and so on, yeah, it is difficult enough to survive in an online environment that is very much in the hands of large platform providers who have been around for years and years and already have quite some infrastructures in place. So I think the proposed legislation addresses this in a quite convincing way.
Thank you. So we are nearing the end of this part of the discussion. So I would like to ask Ludvig to indicate what, in your view, are the top aspects that should be considered during these crucial negotiations that are unfolding, and what should be eventually part of the DSA, and perhaps what should be left outside of it. So Ludvig, your take.
Okay, that's a big question, but I mean, I probably touched on some of these issues already. And well, first of all, I would say it's, of course, imperative not to make things worse. And in a way, I think I sort of talked about that when we talked about search engines and the subsidiarity issues, because those in the current versions, they will actually make things worse, especially or specifically in my world for the world of copyright. Also, I think that the KYBC that we talked about, that is so important, that these rules are applied to all online services, not only to marketplaces. That's sort of I think that might also add on some of the notice and takedowns and notice and actions discussions right now. But I think the KYBC, as many of you talked about, is very, very key for what's happening. And then I think that we should talk about go back to the cross-border discussion to create some kind of new solution or expedited processes to handle cross-border infringement. I think that's been a topic that we've been discussing for the last decades, probably. And I think it's a weak position for Europe to not have a better solution for how to handle these issues when we know that the online world is not nationally coded. It's a global marketplace where we need to be able to act at least within the European Union. I think I stay with those sort of three areas, which I think sort of are most key right now. Thank you.
Thank you. Then I would like to extend the same invite to the rest of our speakers as to what you'd like to see or not to see in the DSA once it exits these closed door negotiations. I don't know if there is anyone who wants to go first. Jaymeen, please.
I was trying to be a gentleman, but no, I think, after what Ludvig said, certainly on KYBC, it would be fully in agreement. And I think we need to be proportional about KYBC and very clear that this is about your business customer. So it's not a blanket obligation to identify all of your users. It's identifying businesses who are paying you money for the use of your services to access customers. Because I think that's sometimes lost in the debate, that it's often seen as a blanket obligation to identify all users. But I think it is an important principle, like I said, because it underpins so much of what we're looking for in an effective notice and action mechanism, including, we hope one day, notice and stay down as well for that content that's put up by business users which have been identified in KYBC. And then alongside it, I think it won't become as any surprise that we think the trusted flagger issue is very important. We understand the concerns about overwhelming the digital service coordinators, but I think that's more a question of practicalities rather than one of principle. And I hope that I've explained the principle clearly enough during this discussion, which has been very, very interesting. And what what I'm happy not to see in it is indeed that principle, which was inserted halfway through the trilogues on stay up, which indeed, agreeing with Linn, would have acted as a clear incentive to process notices as slowly as possible rather than as quickly as possible.
Thank you. Linn, Martin, Clothilde.
I can just add briefly on this. I think we will also co-sign to the wish to have a KYBC provision that is actually useful for audiovisual content and extended to all online intermediaries. And what else we would very much not like to see an exemption or a specific caching safe harbor for search engines as is drafted currently, but rather rely on the current principles of safe harbors. And maybe finally, just to lift the effective notice and action and how it will have to be, as Jaymeen just mentioned as well, that the expeditious action will actually have to be closely linked to the receiving of a notice. So those three things maybe.
Thank you. I don't know if Clothilde and Martin wish to add to this discussion. I would say that something that is not in the DSA but is relevant from an IP perspective is the fact that our enforcement directive harmonizes quite little. So it is a minimum harmonization measure. And I would say that perhaps an even more pressing topic is that of injunctions. We have indeed the provisions on injunctions in both the InfoSoc and enforcement directive, but then, you know, the conditions and modalities are a matter of national law, and sometimes you have very different approaches from country to country. So I wonder whether these might be an area that, if not in the context of the DSA, but in another near future or a remote future, depending on the perspective, should be tackled, considering also the cross-border nature of many infringements taking place today. Okay, so if there is nothing further from our panelists, we thank them very much for contributing to today's discussion. And now we move on to the interplay between the DSA and indeed the DSM directive. We are very happy to host Professor Martin Senftleben. Is someone who doesn't need an introduction, of course. He's a professor of intellectual property law, the director of IVIR at the University of Amsterdam, and he has researched extensively topics of copyright, freedom of expression, the DSM directive, and now also the DSA. So Martin, we are very grateful for your participation, and we look forward to hearing your thoughts on indeed the relationship between these two areas. Thank you.
Well, thank you so much for the kind introduction, Eleonora. I have prepared a little presentation to illustrate what I'm saying. So perhaps somebody could quickly confirm that you see the presentation on the screen. Okay,
we do, yes.
Very good. So this seems to work. Actually, it's quite a complex topic, and I don't have hours for explaining this. So I have made a selection, and I try to describe this in a manner as clear as possible, but I hope we also have a bit of time for discussion, so whatever you would like to raise afterwards. Points of contact between the Digital Services Act and Article 17. Well, first of all, when we look at Article 17 and then the first paragraph, we can say that the crucial change, the system change, you could say that with Article 17.1, the European legislator has established in the field of copyright a direct liability of online platforms for infringing user uploads. So this puts an end to the traditional safe harbor approach. It has been mentioned in the discussion today already. In the United States, we have a specific safe harbor regime in the area of copyright legislation, the Digital Millennium Copyright Act, and in the e-commerce directive, which is called the notice and take down system, we have this horizontal safe harbor regime covering also copyright. And so traditionally the rule was that as an online platform, you are only liable after you obtained knowledge of infringing content and had awareness of infringing content, but you were not directly liable. So this has changed. This safe harbor regime is now eroded with regard to copyright, and instead we have specific liability regime, which is based on the one hand, best efforts to license, and on the other hand, what I would call filtering mechanisms. I don't go into detail here because, well, we could spend hours on only these 2 points, but the topic today is the interaction with the DSA. So suffices to say there is a specific liability regime in Article 17. And then it is important to realize that this is only for a very specific type of online platforms. Very often in the debate, YouTube as an online platform was given as a standard example of OCSSPs, the online content sharing service providers that would fall under this specific copyright regime. YouTube, I think, is a good example. You can discuss how broad this concept actually is, but it is very clear in the legislation itself that another type of platform that we have discussed quite a lot today already, the online marketplaces, do not fall within this regime, even though you could say a couple of copyright related claims are also conceivable on online marketplaces. So it's just for a specific type of online platform. So I mean, as we all like to have a lawyer's paradise in Europe, of course, nobody hesitates to add even a bit more complexity to this whole picture. And the complexity, as we have already understood, comes with the updating of the e-commerce directive in the proposed Digital Services Act, which would be a regulation. With regard to complexity, first of all, the general approach in the DSA is not so much complex or new or anything. It's a continuation of the safe harbor regime that we knew from the e-commerce directive. So the traditional types of privileged ISPs are still there in the Digital Services Act. And so the explanatory memorandum is also clear on saying that this safe harbor principle as a starting point would be maintained for those three types of ISPs, mere query services, caching, and hosting services. But of course, there are many new elements that are added in the Digital Services Act. And in particular, there are distinct regimes that are now established. So on the one hand, specific rules for hosting providers. On top of that, additional rules for online platforms. Then we have even another set of rules for very large online platforms. And I mean, looking at this, you can easily understand that there will be more than enough questions also about how to draw the lines between these different types of regimes and which rules apply to a particular type of online service. But in order to make it even a bit more complex, we also have, with regard to the copyright interface, Article 1.5 of the Digital Services Act, which says this regulation is without prejudice to the rules laid down, and then a reference to the e-commerce directive, the AVMSD directive, and then union law on copyright and related rights. So if you want a complete picture, a family picture of all the individual regimes that we have to take care of, then it's not only the three that I mentioned, the three that are in the DSA, but on top of that, as a lex specialis, we could say, we have the specific regime for online content sharing service providers, and that's the Article 17 of the copyright legislation. Luckily, the Digital Services Act also tells us a bit about the interplay which the legislator has in mind, and this is, in a nutshell, complementary application. The proposed regulation, the DSA, complements existing sector-specific legislation. So existing EU laws regulating certain aspects of the provision of information society services apply as lex specialis, but there is this interaction. So wherever the lex specialis, like Article 17 of the DSM directive, does not provide specific rules, there is room for applying the DSA rules. And now, well, as I said, it's getting more and more complex, in particular because it cannot generally be said that the specific legislation, like Article 17, is always exhaustive and more specific than the DSA. In fact, the opposite is true. In some areas, the DSA adds quite a lot of additional rules. So let me try to give a couple of examples. There's one clear form of complementarity that I would call a direct complementarity. So when we look at Article 27 DSA, it says, the very large online platforms should take effective measures to mitigate risks that are inherent in these platforms. And then one of the mitigation measures that could be taken are content moderation systems. And then we could say, well, this is clearly complementary because then Article 17 in the area of OCSSPs is the specific content moderation rules that apply then in this context. So we have no particular problem of interaction of the legal systems here. It gets a bit more complicated or a bit more nuanced, you could say, when you look at other provisions in Article 17, in paragraph 4c, we have a reference to sufficiently substantiated notices which right holders would have to submit. And when you read a bit further in paragraph 9 of 17, we have also a rule saying that right holders should duly justify the reasons for requests to block certain content. But Article 17 of the DSM directive is silent on what substantiated notice or duly justification and so on really means. And I think this opens the door for reading the DSA provisions and interpreting these Article 17 obligations in the light of what finally will become the notice and action requirements and also the statement of reason requirements. If you like it or not, I think that's exactly what will happen when courts try to find their way through these different provisions. Then I think there are a couple of additions that we have in the Digital Services Act that we can see as clarifications of rules and implications of those rules in Article 17 of the DSM directive. I've already mentioned Article 12, which is about sharing information on restrictions. So information on any policies, procedures, measures, and tools used for the purpose of content moderation. So first of all, there should be information on the fact that content moderation tools are in place and are applied. But then the provision also says, including algorithmic decision-making and human review. And this is, of course, an important provision. The reference to algorithmic processes will raise the question to which extent platforms also have to explain the logic, or perhaps even open the famous black box of AI content moderation systems, which is a bit of a recurring theme in the whole AI debate, with legislators and stakeholders saying we can't say something or regulate something that we don't know. So to which extent these algorithmic processes must become transparent will be a question that keeps us busy in the light of Article 12. And then Article 12 also says something important about the way these restrictions, like content moderation systems, should be implemented, namely in a diligent, objective, and proportionate manner, and in particular in a manner that takes due account of applicable fundamental rights of the recipients of the service. As I said, this is a really remarkable provision. Fundamental rights have traditionally been something that you can invoke as a citizen against state power. And here it suddenly becomes a crucial factor in how a private party, a platform provider, implements certain systems like content moderation systems. So we could say it's a remarkable form of putting fundamental rights obligations in front of a private party and say, you have to deal with this, which may also change the nature of how the fundamental rights are applied and operationalized in practice to quite some extent. Then finally, we have transparency obligations. As an example, Article 13, publish at least once a year clear, easily comprehensible and detailed reports on any content moderation, and then the provision also specifies what information should then be published, including the number and type of content moderation. So we see there is quite a couple of transparency rules that can also impact the Article 17 OC SSB regimes, because I would say these are clarifications of what you are expected to do as a provider of these services. Then we have a couple of additions in the sense of true additions, elements which are not present in the copyright arena at all. And there in Article 20, we have the option of user suspension. So users who frequently provide manifestly illegal content, so we could say the systematic infringer, can, after a prior warning, then be suspended from the service. And Article 20 also tells us that the same can be done with regard to complainants, so who frequently submit notices of infringement and complaints that are manifestly unfounded. So we could say the systematic grumbler who thinks that everything is infringing, which he has not authorized himself. These type of participants in the online communication can also be suspended after a prior warning. So these are important additions, which I mean, in the context of Article 17 implementation, we already see a couple of national systems adopting this. So that's part of the German implementation of Article 17, for instance, without this being in Article 17 of the DSM directive itself. So in that sense, this is an important additional component, which in member states already plays a role without the DSA having been adopted. And then, of course, we have spoken a lot about the trusted flaggers already. This is an additional element that you don't find in the copyright legislation. So kind of a privileged group of flaggers of infringing content. And then if you receive a notification of infringement from a trusted flagger, this information should be processed and decided upon with priority and without delay. And then the status of trusted flaggers will be checked by the digital services coordinator, but at least in the initial commission proposal, one of the criteria was particular expertise and competence, and then representation of collective interests. And as we have heard already, this has raised a discussion which I would call the fox guiding the henhouse discussion. At least in the initial commission proposal, we could read the following: for intellectual property rights, organizations of industry and of right holders could be awarded trusted flagger status, which from an intellectual property perspective is fully understandable and makes sense. But from the perspective of, let's say, the broader spectrum of public interest here, including freedom of expression, freedom of information, and also freedom of conducting a business, it is of course problematic to give one group that has a very clear interest in maximizing enforcement measures the status of trusted flaggers. And well, as we have heard already, that's something that has triggered quite some debate. So that's the little overview that I had prepared. There are further issues, so you could also discuss, for instance, the intersections between the complaint handling mechanisms in Article 17 and the complaint handling rules in the Digital Services Act. So this is something that will keep us busy, I think. As a final word, I have mentioned complexity several times, and I think it's true that there is lots of complexity out there now, but on the other hand, also lots of legal rules and materials that come directly from the EU legislator as a harmonized toolkit for us to develop practice according to the rules. And I think as a toolbox, we must not underestimate the potential of this legislation. There is quite a lot of balancing exercise and good ideas in these proposals. So I'm not necessarily negative about the whole thing. The fact that it is complex does not mean that we can't find proper solutions on this basis. But in comparison with the e-commerce directive, I would say we had, well, hardly any true harmonized material to develop more detailed rules. We now have kind of the opposite, the other pole of the spectrum, with more than enough rules, where we have to find our way through the thicket. So having said that, thanks so much.
Thank you so much, Martin. This was a really comprehensive and very helpful. So to understand it correctly, indeed, this lex specialis, lex generalis relationship will give rise, to several points of contacts. But indeed, as you also noted in your talk, even within Article 17, there are internal lex specialis, lex generalis points. So, for example, only online content sharing service providers are caught by Article 17. You provided the example of marketplaces that are not online content sharing service providers. Then there are, other services for which it is unclear whether they are online content sharing service providers. So this means that the rules under the InfoSoc directive and interpretation in YouTube Siando will continue to find application. Then there has been a big discussion also surrounding the German transposition regarding the nature of the right of communication to the public in Article 17. Is it the same as the other rights of communication, or is it something else? So I guess that indeed there will be a lot to think about for years to come. There is a question, since we have quite a few participants from the UK, that I don't know, Martin, whether you feel like addressing. And the participant is noting that for the DSA to apply, it is required that you direct your services to the EU, but nothing expressly in this sense is said in relation to Article 17. So if you are a UK company, can you be caught within the scope of application of the DSM directive or not?
Well, I mean, as I see the statement in the DSA, this is something which the courts have, of course, developed for a long time. So the fact that it is not explicitly mentioned in the copyright legislation of the EU does not mean that the principle would not apply to the copyright arena. So quite clearly, when you direct your service to an EU audience in one member state, then the courts will be able to go after you. Hardly any doubt about that.
Perfect. Thank you very much. Then, there are other questions regarding the DSA points that we have discussed, but perhaps I would like to ask Martin to comment on the point that we are seeing is that, for instance, there is great divergence already regarding the national transpositions of Article 17. And one big point of contention is that of ex-ante, ex-post blocking of content. So the DSM directive, I would not say that it is crystal clear in going for one approach or another. The European Commission has taken a view. So I would like to ask you whether you can tell us what you think the correct implementation of Article 17 is going to be, considering that many member states, including Sweden, have yet to finalize the process.
Well, yeah, I will try to put it mildly, because Eleonora, as you know, I've never been a big fan of the whole Article 17 approach altogether, but I mean, it has been adopted. We will see what the Poland challenge finally tells us. But I mean, I would not be surprised if, at least in the area of copyright, the final outcome will be that only leaving users with ex post options, complaint mechanisms to do something against overblocking of content and so on will not be enough. So I can really imagine that from a freedom of expression perspective, it will be necessary to find a solution that allows users to do flagging ex ante. In that respect, I mean, there is one system that also, because of my personal background, I know a bit, I've studied a bit, and that's the German implementation. And I think the German approach is much more balanced than the groundwork that we have in Article 17. So I wouldn't be surprised if this is a model which also helps the Court of Justice to finally say, well, there are ways of implementing this which are in conformity with the requirements of the Charter. So from my perspective, ex ante options for keeping content on a platform until it is really established that it is infringing is the safer implementation route. But well, I mean, there's lots of diversity in this debate, so this is just one humble opinion.
So, I understand that you may be ruling out that the Court of Justice would invalidate Article 17 when it issues its ruling in the Polish challenge next month.
Actually, I mean, I don't know. On the one hand, it could be an opportunity for the Court of Justice to make a really strong statement, something which, at least in the intellectual property area, we have not seen before, the Court of Justice nullifying such an important provision. But to be honest, I would really be surprised if that was the final outcome. I would really be surprised, because the Court of Justice is well aware that lots and lots of energy has been invested in finding a solution for this problem. And as it now stands, it's also a question whether, after all the discussions we have had, it is easy to develop a system that is better than what we have in Article 17. Looking at the different implementation avenues that are now explored in the member states, there's only one thing that I find is really a pity, and this is that, well, I mean, we see this aspect of system competition now coming too late. So it is after we had the harmonized rules that the national legislator now experiment with this and find different implementation avenues. It would have been better, of course, to have this system competition first, and then the EU legislator distilling the most promising elements of regulation from the national experiences and come up with a harmonized solution that is yeah, that is something that can be applied in a more harmonized fashion across EU member states. But on the other hand, I mean, in the field of academia, we always have the advantage of complaining afterwards. We are not the policymakers, so it's easy to say we would have known better and to come and propose something that is very clever. But yeah, I guess for the Court of Justice, it's really difficult to now say this is not in line with the freedom of expression guarantee to such an extent that we annul the whole provision altogether.
Thank you. And then as a final question, because we are running a bit out of time, there is an attendee that is asking you very bluntly whether you think that the German transposition is absolutely compatible with EU law.
Yes, of course it is. No doubt about that. That's the best transposition. That really, I think that's the best transposition that we have seen so far, at least looking at the transpositions that are accessible to me in terms of language and so on.
Thank you very much. And I guess that with this final answer, we can reach the closing of today's event, unless one of our speakers would like to add one final word. If not, then I would personally like to thank them so much for contributing to today's event. I would like to extend my gratitude to Alva, IFIM amanuensis and a student at Stockholm University, for all her help putting together today's event. And of course, thank all the participants for being part of IFIM activities also today. If you want to know more about what we do and our future events, please do follow us on social media, follow our website. We will be back later this spring with another event, and we will be unveiling details very soon. So, Per Jonas, I don't know if you wanted to extend one final farewell.
I have counted up to 220 participants, and I would like to thank you also for participating, and thank you to the panelists and to Eleonora and to Alva for all, that is our secretary, for all her efforts with the organization of this seminar. So thank you so much.
Thank you, and see you soon. Thanks again. Bye.
Thank you. Bye-bye.
Thank you, Eleonora.
Bye.
Thank you.